What do you think the doctor is going to say if I ask him as the very first question in his deposition, his pretrial question and answer session, "Doctor, did you screw up? Did you violate the basic standards of medical care?" What do you think he's going to say? You think he's going to admit it? Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, of course he's not going to say he screwed up. Do you think he ever would? The answer is no. He's not going to voluntarily say that. And if I were to ask him that as the very first question during this pretrial question and answer session known as a deposition or an examination before trial, that is absolutely not the first question I want to ask. Instead, I have a lot of better questions that I could ask, and I'll share those with you. So why would the doctor get so upset if immediately the first question I ask him is, "Hey doctor, did you screw up and injure my client?" The answer obviously is, of course not. Why are you suing me? I did nothing wrong. And then I'll turn around and say, you know what? Even if I did something wrong, so did you, Mr. Patient. And he's going to say, if I did something wrong, whatever I did didn't cause or contribute to your injuries. Those are the typical defenses we see in these medical malpractice cases. So now, if I were to come right out and accuse the doctor of screwing up, he's automatically going to get defensive. He's going to get angry and upset. He's going to say, of course I didn't screw up. Of course I did nothing wrong here. Now, that starts me out on a really bad footing. Why? Because during this pretrial question and answer session, I have certain information I need to get from the doctor. There's a certain agenda that I have. I need to establish what the standard of care was from this doctor. Remember, he's a physician licensed to practice in the state of New York. I am entitled to ask him questions about his knowledge and his expertise. And how do I do that? By asking him, "Doctor, are you familiar with the following things? Doctor, tell me what the anatomy is. Tell me when a patient comes in with the following things, what good practice requires that you do. Would you agree it's good practice to take notes? It's good practice to do a thorough physical examination. And it's good practice to record exactly what the patient complained of. Would you agree with that?" And of course, those are the basic things that he has to agree with. When I question the doctor, one of my goals is to get him to tell me what the standard of care was. Now, why do I want to do that? Don't I have my expert for that? The answer is yes, I do. But I want to know from this doctor exactly what the standard of care is, what his understanding of the standard of care was. So now I can contrast that later on with what he actually did compared to what good medical care really is. So now the doctor gets really upset. He gets very defensive. "I didn't do anything wrong. Why are you suing me?" he says. So a better question to ask, the very first one, is the key question in the whole case. Let's say this is a case involving a surgeon who operated on the wrong side of the brain. Now, most attorneys, when they approach that question and answer session, and now they're going to question the doctor who did that surgery, they're going to go ahead and start off by asking the doctor questions about his credentials. "Doctor, where did you go to school? Where did you do your training? Where did you learn how to perform surgery?" And you know what? An attorney who's preparing for that pretrial deposition should have that information and should be required to get that information. But guess what? I don't need to get it at the beginning. I typically like to get it at the very end. So if I save that for the very end, how am I starting my questioning? I like to ask the key question in the whole case. "Doctor, would you agree that operating on the wrong side of the brain would be a violation from the standard of care?" And his attorney will get all flustered and start objecting. "Objection, objection, you can't ask that question right off the bat. You need a foundation." Really? Where does it say in the CPLR that I need a foundation to ask the key question in the whole case? "Doctor, would you agree that operating on the wrong side of the brain would be a violation from the basic standards of medical care?" He has to admit it, ultimately. So now, if the attorney still argues with me and says that I need a foundation in order to ask that key question, fine, I'll go ahead and ask foundational questions. What are those? It's to establish that the doctor had a relationship with my client. "Doctor, this was your patient, true?" "Yes." "And the patient came to you because they had a problem, true?" "Yes." "And you diagnosed this particular problem in their brain, isn't that correct?" "Yes." "And you recommended surgery to them, right?" "Yes." "And in fact, you told them that the problem they were having, which now shows up on the right side with symptoms, is actually a problem on the left side of the brain, isn't that true?" "Yes." "And you told them that you would be operating on the left side of the brain, isn't that true?" "Yes." "Now, on January 1st, you performed surgery on this patient, correct?" "Yes." "And you performed it at this hospital, isn't that true?" "Yes." "Doctor, you intended to perform surgery on the left side of this patient's brain, isn't that true?" "Yes." "Can you explain to me, doctor, why you operated on the right side of the brain?" That's how you lay a foundation in order to establish something so obvious where the doctor operated on the wrong side of the brain. Now, if it's something a bit more subtle and nuanced, I can't come right out and say, hey doctor, did you screw up? That's the wrong way to get that information. Instead, I have to establish what was the standard of care. I have to establish from this doctor what is good medical practice. Then I will go through with him what he did in this particular case. Go through every single page of his notes. Go through every single entry in his notes. Now he tells me exactly what he did. And he also tells me that that represents good and accepted medical care. Now here's something interesting that you may not know. All of these medical malpractice cases involve disputes, factual disputes. We claim that the patient told the doctor about something, the doctor denies that, and now it's a dispute. So one of the things that I have available to me when I question the doctor during his pretrial deposition is the ability to ask the doctor hypothetical questions. So here's an example. Doctor, I want you to assume that on January 1st, my client came to you with the following complaint. No, I understand that you dispute that, but I want you to assume that this patient complained to you of A, B, and C when she first saw you on January 1st. Okay, let's assume that's true. Would you agree that in that instance, good medical care required you to do X, Y, and Z? True? Now the doctor has to admit that. He doesn't agree factually that that's what happened, but if we ask him to assume that those things did take place, yes, good medical practice requires that you do X, Y, and Z. Okay, doctor, now I also want you to assume that the patient had the following other complaints when she came back to you a week later. Would you agree that in that instance, it would be appropriate to do X, Y, and Z again? And again, he's got to acknowledge and agree that yes, in that circumstance, it would be appropriate to do those things. Okay, so now let's change up the hypothetical. And I will go through a series of hypothetical questions, and the doctor will not want to answer them voluntarily. He will often turn to his attorney and say, do I really have to answer that? And the attorney will object as well, but will tell the doctor, go ahead and answer that question. Now, why is this such a useful tool for me in order to obtain this useful information? I'll tell you why it's so crucial to ask hypothetical questions. If the case ultimately goes to trial, now at trial, what is the jury doing? They're trying to evaluate who is more believable. They're trying to evaluate whether or not we, as the injured patient, bringing the claim on your behalf, is more likely right than wrong, slightly more likely right than wrong. And if we are, if our version of the events is more believable, now what have I done? Now the doctor has admitted in his own words that if they believe our version of the facts, the doctor has already told me during his pretrial testimony that yes, it would be appropriate to do X, Y, and Z. But doctor, your notes already reflect that you did not do X, Y, and Z, is that correct? Yes. And you would agree that in that instance, if you did not do X, Y, and Z, that would be a violation from the basic standards of medical care, isn't that true? And he has to answer yes. So why do I share this great information with you? I share it with you just to show you exactly what happens in these medical malpractice cases. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.